Payroll funding on collateral of all assets. Staffing companies and other seekers of payroll funding are often too focused on pricing to the exclusion of other important elements. The legal description of collateral for the loan must be scrutinized before signing up with a funding company. At one end of the spectrum, a payroll funding company may be secured on accounts receivables only. At the other end of the spectrum, the funding company may list all assets of the business or debtor as the collateral. The pledge of all assets is generally known as a blanket lien, as it covers everything. And unbeknownst to most people, a blanket lien can encompass a shocking range of assets. Dazzled by other funding company enticements, such as software or price teases, staffing company owners often sign up to give away all assets. In the payroll funding marketplace, there are many good lenders that will advance funds based on accounts receivables only, and the pricing, when made apples to apples, is the same. So why give away all assets when you really don't have to? It may only be for lack of information or legal advice that the staffing company signs such a contract. Few people have any idea what the term all assets can encompass. It may include all assets of the debtor anywhere, current or future, such as all personal property other than goods, accounts, documents, instruments, money, business records, designs, patents, trademarks, copyrights, confidential information, licenses, franchises, tax refunds, security interests, all accounts, meaning any right of the debtor to receive payments, inventory, materials, equipment, furniture, and accessories, plus the proceeds from the sale of any of these things, and much more. Before a lender takes all assets as collateral, one must closely examine the funding agreement and all related contractual elements, as there can be a wider range of default circumstances. Someone signing a payroll funding contract might think they want the funding company to have all possible business collateral because they believe that in case of default, the funding company must liquidate all of the business collateral before they can legally go after one's personal assets. This is not always true. In many cases, the lender is under no obligation to go after business assets before attacking personal assets. There is another problem when a funding company perfects its loan on all assets. Other companies, such as leasing companies or SBA lenders, may be secured on the same assets, which may require legal agreements to determine who gets what in a financial or legal meltdown situation. There are even suppliers that will simply refuse to do business with you as soon as they learn that other parties are secured on the same assets. For example, as your company grows, you may need to lease computers. The leasing company may refuse to lease their computers to you when the funding company has all assets, because the funding company has legally taken all of the equipment as collateral. In this case, a subordination agreement may have to be worked out, and if the funding contract provides that you pay all legal expenses, guess who ends up paying for the subordination agreement? One must check all clauses in a payroll funding contract for items regarding responsibility for legal costs. See the Flexible Funding website for the payroll funding article on legal cost for an idea of how far these legal costs can climb. And for more detailed information about the importance of payroll funding collateral, see our webpage for payroll funding articles at www.flexiblefund.com.